So computer scientist Stephen Thaler, he created a computer program called Davis that generated inventions. And Thaler, he filed several patent applications in the US and actually elsewhere in the world, with Davis included as the only inventor on those applications. And the USPTO ultimately did not allow those applications to proceed based on a lack of a human inventor. And the Federal Circuit agreed, ruling that an inventor for purposes of the patent application must be a human. And earlier this year, Thaler petitioned to have his case considered by the Supreme Court. And Mike and I drafted an amicus brief in support of Thaler.
The issue that we mainly focused on was the fact that the Federal Circuit and the USPTO, by extension, had only considered one side of the equation. The issue was decided as a matter of statutory construction. The statute was ambiguous. It could have been read either way, but the PTO and the court decided to read it one way in order to limit inventorship to that of a natural human person. So first of all, we don't think that the statute necessarily needs to be read in this way, especially when you consider the congressional intent behind the patent statute itself, which is to promote the disclosure of inventions. So if you have an entire swath, an entire category of inventions that are AI related or AI generated that cannot be patented, then this disclosure incentive is going to be reduced. So we think that that was actually contrary to the congressional intent behind the patent statute. And in doing so, what's going to happen is that as these AI models get better and better over time, their ability to innovate on their own is only going to increase. And so as a result, there's going to be a higher proportion of inventions being made by AI that may never, ever be able to be seen by the public because there's no point of commercializing them if you can't protect them with a patent. If you ask a really advanced large language model to design a new way of manufacturing insulin at a low cost, and it actually does, if the AI is the sole inventor, nobody's going to be able to get a patent on that process. And so whoever is aware of that process, whatever human is aware of that process, might just decide never to commercialize it. And so therefore, millions of people could suffer as a result.
The only way companies will be able to prevent competitors from using their AI invented innovations, the way the Federal Circuit currently is constructing the term inventors, is if they hide those inventions from the public and keep them secret. So if we don't allow for AIs to be inventors in the sense of the U.S. patent law, we're going to become less innovative in the U.S. and our head start in AI globally is really going to be diminished. Yeah, I think co-inventorship with AI is definitely going to happen in the near future. I mean, in fact, similar to the U.S. Copyright Office, the Patent Office is also undertaking a study of how AI and potential policy issues that arise because of AI, and studying how the patent law might change and adapt to this disruption. So I think in the future, as AI becomes more and more powerful and is used more and more in the inventing process, the Patent Office is going to necessarily need to find a place for AI as at least a co-inventor.
Under Thaler, having anybody involved in the conception or anything involved, I should say, that's not a human is going to be very, very problematic. I think it's one thing to maybe use AI to help develop some additional embodiments that have already been, conceived of by a human inventor, but anything beyond that is fraught with risk.